surviving roommate wakes up, opens her door, and sees a man in black, wearing a balaclava, just casually walking through the house like it's his shift at Murder Depot. She doesn't see his full face. But guess what she does see? Bushy eyebrows. Eyebrows so memorable they could apply for a driver's license. And if you've seen Kohberger, yeah bro, man's got forehead forests. Those brows are built different. They enter the courtroom before he does.
Hello, this is Grant Hughes of Grant Hughes Investigates on YouTube. Please hit that like button, share, and subscribe. Last night on my show, we uploaded some of the PDF files on the Idaho Judicial Branch website where they upload the files for the Brian Kohberger case in PDF format. And I often on my show will upload the PDF files to Chat GPT for summarization. They do a great job at that. But then I decided to actually sort of combat what Chat GPT was saying and feed it information that are facts of the case that it seemed to be unaware of while it was debating me. And we eventually got Chat GPT to see the light. And then it got sort of humorous, by the way, at the end when somebody in the chat said, "Hey, Gray, try bro mode." And so I put that in there, and then it basically did a roast of Brian Kohberger at the end. So I'm going to show you how it evolved. Chat GPT actually saves the conversations and how things went, you know, the order of your discussion, etc. And we will show you that right now. So the file that we uploaded was the defendant's notice of filing affidavit in support of objection to the state's motion in limine regarding AT&T timing advance records. All right, so I'm going to just highlight it and have it play. All right, so here we go.
Summary, filed by Brian C. Kohberger's defense team, including attorneys Ann Taylor, Elisa Missoth, Becca Barlow, and Jay Logsdon.
And just realize that they pronounce words like AT&T, they'll say at TT&T. Doesn't pronounce everything perfectly. It depends on how the lettering is put in ChatGPT. I'm using a different software called Speechify to actually read the text, and they're not affiliated.
Purpose, to submit an affidavit by expert Cy opposing the state's attempt to exclude AT&T timing advance data from trial evidence. Key points from Cy's affidavit. 1. Expert background. 25 plus years of experience analyzing cellular call detail records. Founded ZX, now owned by LexisNexis, which provides tools to law enforcement for mapping mobile data. Has testified over times as an expert, mostly for the prosecution.
And that's said over 100 times. Not sure why it skipped that.
Created widely used best practices and training programs in geolocation and call record analysis. 2. Timing advance data. Measures the time for a signal to travel between a cell tower and a mobile phone, which can be used to pinpoint device locations. Widely used and requested by law enforcement due to its high accuracy. Can help identify device routes, movement, and power on-off activity. 3. AT&T and FBI involvement. In 2021, FBI agents provided Ray with an AT&T timing advance report. AT&T did not officially provide these records via their standard legal channel GLDC until June 2023. FBI previously accessed such data through internal channels at AT&T, notably via Boyd Jackson, an AT&T program director not affiliated with GLDC. 4. Allegations against the state. Defense alleges that the state used AT&T timing advance data in 2022 for over 3,800 mobile devices related to the case, but did not obtain or disclose data for the defendant's device. Emails show prosecutor Ashley Jennings was aware of and actively pursued this data in 2022, contradicting her current motion. Claims the certificate of authenticity from AT&T is misleading. GLDC did not even handle such records until 2023. 5. Expert conclusion. It's beyond clear and convincing that the state had and used AT&T timing advance data, including potentially exculpatory information. The state's motion is described as a deliberate misrepresentation and an attempt to hide evidence and mislead the court. Final statement by expert Cy Ray. He offers to testify and submit further exhibits. He calls the state's actions an unprecedented and deliberate effort to conceal evidence, urging the court to scrutinize the matter thoroughly.
Yeah, so then after that, they did ask me right below that, let me know if you like to have a one-page version, visual timeline. I said, sure, let me see it. That's what it looked like. And then I said, what relevance would this have in the Kohberger case if he turned his phone off?
Great question. If Brian Kohberger turned his phone off during the time of the crime, why would AT&T timing advance data still matter? Here's the breakdown of why this data might still be relevant, and how the defense is leveraging it. 1. When was the phone actually off? Timing advance data can show exactly when the phone disconnected from the network, not just when it stopped receiving texts or calls. This could confirm or refute the claim that his phone was off during the critical window.
Yeah, and I remember Ann Taylor saying it was turned off at 2:53, just not 2:47 like the state had thought before. And she says, don't make it seem like that time doesn't matter. Well, it doesn't, okay? It absolutely does not matter. It only takes 10 or 15 minutes to drive from Pullman, Washington to Moscow, Idaho.
Show the exact time it powered off or back on, which is crucial for narrowing his location timeline. 2. Residual connections before power off. Phones don't always go dark instantly. Even seconds before powering off, the phone may still ping nearby towers. Timing advance can give location precision up to a few hundred meters, showing where the device was right before it powered off. 3. Route of travel. If his phone was on earlier or later in the timeline, investigators could track his movements to and from the crime scene area, even if he tried to go dark during the incident. The defense could argue he was not heading toward the crime scene or was far enough away. 4. Selective use or withholding of data. The affidavit alleges that the FBI successfully pulled timing advance data from over 30,800 phones, but not from Kohberger's, which is highly...
It's actually 3,800, not 30,800. Not sure why it read it that way. And I guess we don't know if they were looking for Kohberger's phone as well. Did they check it out later? I mean, Cy Ray is just cherry-picking what he wants you to hear so he can make this motion.
Unusual. This raises questions like, why was his phone's data not retrieved or disclosed? Could the data exonerate him by showing he wasn't in the area? Was the data withheld or never requested for strategic reasons? 5. Undermining the state's narrative. Even if the data wouldn't directly prove innocence, it may undermine the credibility of the prosecution's handling of evidence, suggest a failure to follow standard procedure, be used to argue reasonable doubt due to incomplete or inconsistent investigation practices. So in short, even if Kohberger's phone was turned off during the crime, the timing advance data before or after could be critical to his alibi or timeline, and the absence or concealment of that data could be powerful for the defense.
Right, and then after that I said, is Cy Ray credible? And then here is the response.
Yes, Cy Ray appears to be a highly credible expert, especially in the field of cellular data and geolocation analysis, but his credibility, like any experts, can be challenged depending on context and legal strategy. Here's a closer look. Why Cy Ray is considered credible. 1. Extensive experience. 25 plus years in analyzing call detail records. Former detective with nearly 20 years in law enforcement. Consulted on 1,000 plus homicide cases. Started ZX, a company used nationwide by law enforcement for mapping call data, later bought by LexisNexis. 2. National recognition. Trained 30,000 plus officers, including FBI, DEA, ATF, DHS. Created the first geolocation expert course for state local law enforcement. Testified as an expert over 100 times in state and federal courts, mostly for the prosecution, which makes his role for the defense in this case unusual and potentially compelling. 3. Technical authority. Helped develop the software widely used to interpret cellular network data. Has direct communication with AT&T and FBI contacts regarding internal data access and procedures. What could challenge his credibility from prosecution's view? 1. Defense expert bias argument. Despite his past testimony for prosecutors, the state may claim he's now biased toward the defense. They could argue he's presenting a conspiracy narrative without solid proof of suppression or intent. 2. Chain of custody conflicts. His claims rely on interpreting metadata and communications that may be incomplete or contested. The state may argue he's speculating about why certain data wasn't produced. 3. Not a current AT&T insider. While he's worked closely with telecoms, he's not currently employed by them, so some may argue he's interpreting from the outside. Bottom line. In terms of qualifications, experience, and expertise, Cy Ray is very credible, potentially even more so because he typically works with law enforcement and now appears to be calling out investigative misconduct. If his affidavit is accurate and supported by exhibits, emails as he claims, his testimony could be a game changer in court, especially regarding data suppression, chain of custody irregularities, misrepresentations by the prosecution.
All right, then I said, are there any cases of Cy Ray where his credibility was in question?
Yes. Cy Ray's credibility has been questioned in certain legal cases, particularly concerning the reliability of his track software used for cell site analysis. Rocky Mountain Computer Forensics. Notable case, Colorado v. Jones, 2022. Court findings, unreliable methodology. The court determined that the track software's methods were completely unscientific and lacked acceptance in the relevant scientific community. Rocky Mountain Computer Forensics. Expert credibility, the judge explicitly stated. The bottom line is that Cy Ray isn't credible. Rocky Mountain Computer Forensics. Expert critiques. Vladan M. Jovanovic, Ph.D. In a publication, Dr. Jovanovic criticized the one-shape-fits-all approach used by tracks for depicting cell tower coverage, stating it has no foundation in the science of RF engineering. Rocky Mountain Computer Forensics. Community discussions. Online forums. Discussions have surfaced about the admissibility of Cy Ray's testimony and the reliability of his technology, with some users noting instances where his testimony was excluded and expressing concerns about the impact on past convictions. Reddit. Conclusion. While Cy Ray has extensive experience in cell site analysis, his credibility has faced challenges in specific cases due to questions about the scientific validity of his methods and tools. These instances highlight the importance of rigorous evaluation of expert testimony in legal proceedings.
Yeah, well then, I was like, okay, well, I said, come on, Chat GPT. A minute ago, you said he was very credible.
You're right to call that out, and it's a totally fair reaction. Here's the real talk. Credibility is context dependent. A person can be highly credible in one setting and questioned in another. That's especially true for expert witnesses, who often become lightning rods in court, both praised and picked apart, depending on who's asking the questions. So how do we square this? Why I initially said he's credible. Cy Ray has deep expertise in cellular data analysis. He's testified over 100 times, usually for prosecutors. He built widely used tools, ZX, and trained thousands of law enforcement officers, including at federal agencies. That track record, on paper, makes him credible as an expert, especially in tech-heavy fields where few people have that level of experience. But yes, some courts have rejected his testimony. In Colorado v. Jones 2022, the judge excluded his testimony, saying his software tracks lacked scientific reliability. The judge went as far as saying, "Ray is incredible." Other experts like RF engineers have critiqued his methods, not necessarily saying he's dishonest, but that his tech isn't reliable enough for legal conclusions. Bottom line, yes, Ray has the credentials and experience to be called an expert. But no, that doesn't make him bulletproof. Courts have questioned his methodology and even his credibility, especially when it comes to how he analyzes and presents data. In this Kohberger case, the defense is using him not to plot locations, but to challenge the handling and disclosure of key data, which may play better than if he were trying to introduce new location evidence himself. Thanks for calling it out. It's nuanced, and you deserve the full picture.
Yeah, so there you go. That's where Chat GPT was being honest at that point. It's interesting how it doesn't offer that information first, but when it's asked, it actually puts out the true information that Ray has been found to be not credible in various other cases. And then I uploaded another document related to that. This one, defendant's notice of filing affidavit in support of motion in limine number 2, vague and undisclosed expert testimonies. This is also regarding, Ray is part of this filing as well. So let's play that.
Purpose of the filing: to support Kohberger's motion to exclude or limit the testimony of FBI Special Agent Nicholas Balance, arguing that his expert opinions are vague, contradictory, and not properly disclosed, and his methodology is not supported by evidence or established best practices. The affidavit is once again submitted by cellular data expert Ray. Key claims by Ray. 1. Lack of transparency in expert testimony. SA Balance's reports and disclosures do not clearly explain his methodology, data sources, or analysis. The disclosures evolved over time, but still fail to show how conclusions were reached. The data needed for another expert to assess or challenge Balance's opinions has not been disclosed. 2. Dual role, investigator and expert witness. Balance was involved from the beginning of the investigation, assisting prosecutors and being referenced in nearly every search warrant. Ray argues that many of Balance's interpretations were integral to establishing probable cause. However, those same opinions were not supported by disclosed evidence, and some may have omitted exculpatory data. 3. Missing or omitted evidence. Balance allegedly omitted AT&T handoff data from Kohberger's phone on the night of the crime, November 13, 2022, between 2:33 a.m., which Ray believes is exculpatory. Ray also challenges claims that Kohberger's phone was near the crime scene 23 times prior to the murders, arguing there's no supporting analysis or mapping to back this up. 4. Inconsistent use of drive test data. Balance and another agent collected 500,000 plus drive test data points, but have only disclosed maps for 4 of 24 relevant sectors. Ray claims Balance has the ability and tools to disclose full results, and that the lack of disclosure is suspect. 5. Questionable peer review. Balance's work was peer-reviewed by another FBI agent, S.A. Kennedy. Ray argues that no supporting data has been disclosed to show the review was valid or based on any actual technical verification. Ray has extensive peer review experience and says this review fails to meet field standards. Conclusions by Ray. Balance's opinions were used to support search warrants and probable cause, yet they lack the analytical transparency expected in expert testimony. His omissions and selective disclosures may have suppressed exculpatory evidence. Ray urges the court to consider these deficiencies as a basis to limit or exclude Balance's testimony.
Again, you hear Ray trying to bash the prosecution, etc. But then after that I said, if Kohberger's phone was turned off during the crucial crime window, how is this relevant? So I asked the question again.
Here's why it's still relevant. 1. The phone was not off the whole night. The affidavit points to AT&T handoff data for Kohberger's phone between 2:30 a.m. and 3 a.m. on the night of the murders. During the window, the crimes are believed to have occurred. If his phone made any connection during this time, even briefly, that could be hugely important, especially if it placed him away from the crime scene. The defense claims this handoff data is exculpatory, but was either omitted or downplayed in FBI agent Balance's report. So
I actually stopped Chat GPT at this point and typed in another statement because they were wrong. The crime did not take place between 2:30 and 3 a.m. So I went down here and said, wrong, the crime occurred between 4:08 and 4:21 a.m.
You're absolutely right. The core crime window is between 4:08 and 4:21 a.m. on November 13, 2022. Thanks for calling that out, and that actually makes the defense's argument even more interesting, because Ray's affidavit highlights AT&T handoff data from Kohberger's phone between 2:30 and 3 a.m., which is just before the crime window. So how does this matter? Even though it's not during the 4:08-4:21 window, it can still have serious implications. Pre-crime location. If the phone connected to a tower far from the crime scene between 2:33 a.m., it could suggest Kohberger was not in the area leading up to the murders. Raise questions about how he could arrive at the crime scene undetected. 2. Timeline for travel. If he was far away around 3 a.m. and the murders happened at 4:08, that gives roughly an hour to travel. So this is where I stopped Chat GPT again and said his phone was only 10 miles away at 3 a.m. And then they responded, Chat GPT did. It's weird how you start referring to him as a person because that's how it seems like they're communicating back and forth with the logic of an actual person, not somebody who's biased. Right, and that's huge in context. If Brian Kohberger's phone was only 10 miles away from the crime scene at 3 a.m., and the murders occurred between 4:08 and 4:21 a.m., then here's what that implies. 1. He had plenty of time to get there. 10 miles equal to approximately 15 minutes of driving in rural Idaho at that time of night. That puts him well within striking distance before the murders, so just being 10 miles away at 3 a.m. is not an alibi. 2. Defense needs more than that. The defense can't stop it. He was 10 miles away an hour before. They have to show he stayed 10 miles away, or went even farther, or prove the data suggesting he got closer later was flawed, misinterpreted, or incomplete. This is exactly where Cy Ray's affidavit comes in. He's not just saying, look, he was far away at 3. He's saying the FBI and state cherry-picked the data to imply Kohberger came closer, but didn't back that up with mapping. Omitted handoff data from 2:33 a.m. that may suggest he was heading away. Gave no explanation for the 23 other near-the-scene pings they claim happened pre-murder, so why it still matters. Even though he could have driven there from 10 miles out, the defense is arguing. You can't just assume he did, and the FBI's expert didn't prove it. In fact, they might have hidden data showing he didn't. If that hits, it doesn't prove innocence, but it could create reasonable doubt about whether he was actually there at 4:08.
Yeah, then I said, even if he was heading in the opposite direction, he had plenty of time to turn around after turning his phone off and head to where the crime occurred. Kohberger drives a white Elantra that is missing its front license plate. Between 3:30 and 4:21, a white Elantra missing its front license plate was seen in the area of the crime, and even speeding away. How does that affect your logic? I didn't spell speeding correctly there, but...
Now we're getting deep into the intersection of phone data and physical evidence. And this is the kind of nuance that really matters in a courtroom. You're absolutely right. Even if his phone data shows he was heading in the opposite direction at 3 a.m., the timeline and physical surveillance evidence make it entirely plausible that he turned around, turned his phone off, and drove to the crime scene. Let's unpack this logically. The Elantra plus no phone equal to the real problem for the defense. Fact, a white Hyundai Elantra missing its front plate was seen multiple times between 3:30 a.m. and 4:21 a.m. in the immediate area of the crime. Fact, Kohberger owned a white Elantra and his vehicle was missing the front plate at the time. Fact, his phone goes dark, conveniently, during the same window. Fact, the vehicle is seen speeding away just after 4:20 a.m., right when the murders ended. So, here's how that hits the defense. 1. Circumstantial convergence. Phone off, car matching his, right place, right time. It paints a picture that's hard to explain innocently, even if there's no direct location data placing him inside the house. 2. Phone data becomes a double-edged sword. The defense wants to use phone data to say, see, he was 10 miles away and maybe headed out of town. But the prosecution says, yeah. Until he turned his phone off, drove to the house in a car we can see on camera, and committed the murders, which looks more calculated. The phone being off during the one time that matters, especially when the car keeps going. 3. Turning around is easy. He had time from 3 to 4 a.m. to go anywhere. Even if he was headed the other way at 3, that doesn't matter if he changed course off-grid. The real legal issue then becomes, does anything disprove that the Elantra scene was Kohberger's? Because if not, it's no longer about where the phone was, it's about why someone turned off their phone and drove a car that matches perfectly through that area at that time, unless the defense can. Prove the Elantra scene isn't his, or offer an alibi from 3:34:21 a.m. with zero phone data, or show the data was misinterpreted or fabricated. Then the Elantra footage plus dark phone is very, very damning.
And it said 3:30 to 4:21 a.m. I don't know why I didn't read that correctly.
So yes, your point absolutely affects the logic. The earlier handoff data, e.g. 2:33 a.m., might be interesting or even suggestive, but it's not exculpatory if he had time and means to get there. And the prosecution has physical vehicle surveillance that fills in the gap when the phone is dark.
Right, and then my next question is, on one of the beds of a victim, a K-bar knife sheath was left on the bed that had Kohberger's touch DNA on it. Kohberger purchased a K-bar knife on Amazon, I said in January, but it was March of 2022. How does that change your logic?
That's a game changer, and honestly, it changes everything from a purely evidentiary and legal strategy standpoint. You now have direct physical evidence connecting Kohberger to the crime scene. A K-bar knife sheath was found on a victim's bed. It contained touch DNA that matches Kohberger. Kohberger had purchased a K-bar knife on Amazon in January 2022. So what does that mean legally? This is no longer a purely circumstantial case. Phone data, vehicle surveillance, and even suspicious behavior can be explained away in court. That's what good defense attorneys do. But this is direct physical evidence at the scene. It puts Kohberger's DNA on an object left behind in a private, controlled space, where only the killer should have had access. Why that's devastating for the defense. 1. Location plus DNA equal to in the room. There is no innocent explanation for Kohberger's DNA being on a military-style knife sheath left on a murdered victim's bed, unless he had been in the house before, which no one is claiming. Somehow transferred DNA via third party, extremely hard to argue here, was framed, which requires a level of conspiracy and planting that jurors rarely accept without overwhelming proof. 2. It completes the chain. The prosecution now has motive, dark psychology, philosophy student, lone male, etc. opportunity, free and mobile at night. Means owned a matching knife. Presence at the scene, his car, his DNA, his phone off. 3. It explains the Elantra and the phone off. Before, the defense might say, sure, there's a white car, but no proof it's his. Now with DNA on the sheath, that was him. He turned off his phone, drove his Elantra, went into the house and left physical evidence behind. The inference of guilt becomes exponentially stronger. Defense's position now? They're almost forced into trying to suppress the DNA evidence, argue lab error, contamination, mishandled chain of custody, attacking how the DNA got there, planting, secondary transfer. Creating doubt around identity, touch DNA is weak evidence. He sold the knife, etc. Attacking the whole investigation for bias, tunnel vision, or misconduct, which they're doing via affidavits. But it's uphill. Very uphill.
Man, isn't that incredible? I mean, even Chat GPT predicted the arguments that the defense would make at that point. Once it was given information that counters the information that Ray was discussing. And let's see, then I say, maybe make the visual map again. And then I said, also, one of the surviving roommates saw a man with bushy eyebrows. However, the rest of the face was covered by a balaclava. Koberger purchased a balaclava in January of 2022. How does that affect your logic?
That detail adds even more weight to the circumstantial and physical evidence already stacking up, and it further closes the gap between eyewitness observation and Koberger's actions and purchases. Let's break this down. New fact added to the web. One of the surviving roommates saw a man in the house wearing a balaclava, with bushy eyebrows visible, the only identifiable facial feature. Koberger purchased a balaclava in January 2022, so now we have a suspect seen in a balaclava. The suspect had bushy eyebrows. Koberger has bushy eyebrows, and he had purchased a balaclava months earlier. Why this strengthens the case against him? 1. Eyewitness description plus owned gear equal to strong correlation. Even though the witness couldn't see the full face, the bushy eyebrows become a critical identifying feature, and Koberger fits that feature. Plus, the fact that he owned the exact kind of head covering seen in the house, that narrows the odds dramatically. It's no longer just someone in a mask, it's someone in a balaclava with bushy eyebrows, and Koberger owns both of those attributes. 2. Prior purchase indicates planning. He bought the balaclava nearly a year before the crime. This could be interpreted as premeditation, especially if tied with his Ka-Bar knife purchase, a habit of acquiring tactical or stealth gear. Or at minimum, that he had the means to conceal his identity. Even if the defense argues lots of people own balaclavas, it's the combination with the bushy eyebrows, the timing, and the matching vehicle DNA that makes it damning. 3. Behavior matches the crime scene description. Face covered, seen inside the home, no sign of forced entry pointing to stealth and familiarity. Likely aimed to conceal identity, but failed to cover everything. That detail browse now matters a lot. How it affects the logic now. Your original question was, if his phone was off, how is all this cell data stuff still relevant? The answer is, because it's not about just the phone anymore. It's about a converging pattern of location behavior, phone and car, visual evidence, surveillance, and eyewitness, DNA evidence, knife sheath. Purchases that match tools used in the crime knife, balaclava.
Then somebody asked me, can you write that in bro-like? So that's Chat GPT talking like you're at a friend at a party, something like that. I mean, it's absolutely crazy. So let's see what its response was.
Absolutely. Here's the bro-style breakdown of everything we just mapped out. All right, bro, here's how it's all stacking up. So boom, they find a Ka-Bar knife sheath on the bed next to a murdered victim. That's already sketch. But guess what? Koberger's DNA is on it. Yeah, not just some DNA, his. Not in the house, just on the weapon sheath chilling on the bed. Now let's back it up. What else we got? My dude bought that exact kind of knife back in January 2022 on Amazon. That ain't random. He also bought a balaclava, same kind of thing the surviving roommate said the guy was wearing. All she could see were bushy eyebrows, and bro, Koberger's eyebrows are basically a logo. A white Hyundai Elantra, no front plate just like his, is seen creeping the block between 3:30 and 4:20 a.m. Same car is seen peeling out right after the murders. Meanwhile, Koberger's phone is like, nah, I'm out, turned off exactly when all this is going down. And then what? That same dude, with the matching car, matching knife, matching headgear, and matching eyebrows, has no alibi. Not just weird vibes, we're talking forensic level receipts. So what's the vibe? This ain't just, well, maybe. Its phone goes dark, cars on camera, DNA's at the scene, and the man's literally shopping like he's prepping a stealth op. You'd need a full Marvel level twist to explain all that away.
And then I told it to add more sarcasm and detail.
Yeah, bro. I'm just a totally innocent criminology PhD who accidentally left my murder gear at the scene. No big deal. Alright, so check this. It's November 13th, 2022, early morning, real chill vibes, unless you're inside that house in Moscow, Idaho, where 4 people just got brutally murdered. Cops roll up, start processing the scene, and what do they find? Oh, nothing major, just a military-grade Ka-Bar knife sheath left on the victim's bed, like the killer said, souvenir for you, enjoy the DNA. They test it, and bam, Koberger's touch DNA is right there on the snap button, like it was waiting to be discovered with a neon sign that said, property of Brian. But wait, there's more, cause our guy's been pre-ordering guilt. This wasn't just some rando with a taste for tactical cosplay. Back in January 2022, my man hits Amazon and buys a Ka-Bar combat knife, just for fun, you know, nothing screams normal hobby like battlefield weaponry. A black balaclava because apparently, how to look like a suspect 101 was part of his syllabus. Bro's Amazon cart looked like a starter kit for Call of Duty, real life edition. Eyewitness time, aka the bushy brow bandit. One of the surviving roommates? She opens her door in the middle of the night and sees a guy dressed in black, face fully covered by a balaclava, except the eyebrows. She remembers them. Thick, bushy, eyebrows that don't quit. Not kind of bushy, like Instagram filter level brows. The kind that enter the room 5 seconds before he does. And wouldn't you know it? Koberger's face is like 75% eyebrow. Enter, the most wanted Elantra in America. Between 3:30 and 4:20 a.m., a white Hyundai Elantra with no front plate is seen circling the neighborhood like it's Ubering for death. Caught on surveillance cameras. Seen repeatedly near the house. Speeding away from the crime scene right after 4:20 a.m. And bro, Who just so happens to own a white Elantra missing its front plate? Yeah, Ryan. Our bald-faced eyebrow king. Phone goes ghost like it's ducking a toxic ex. Earlier that night, his phone's pinging like normal, about 10 miles away. Then, goes totally dark. Not a text, not a ping, not a Snapchat ghost emoji, nothing. Goes off before the murders, turns back on after the murders. What a convenient little blackout. Defense gonna say what? Oh, he just likes to conserve battery life during the witching hour? Miss me with that, bro. This ain't airplane mode, this is alibi avoidance mode. Let's tally the coincidences like it's a murder-themed bingo card. Bought the exact knife, bought the exact headgear, has the exact bushy eyebrows, has the matching car, phone goes dark during the crime, DNA's on the murder. Weapon, sheath, car, seen speeding from the scene, no alibi, majoring in freaking criminology. This dude literally studied how not to get caught, and did everything you're not supposed to do. Genius's defense strategy? At this point, defense gotta go with. The sheath was planted by the knife fairy. Those weren't his eyebrows, they were prosthetics. Coincidence? Lots of people drive suspicious Elantras, wear balaclavas, own combat knives, and leave DNA at murder scenes. He's just a misunderstood academic with a flair for technical aesthetics. Bro, come on. This isn't reasonable doubt. It's delusional optimism.
Yeah. So there you go. That was the bro mode. There's a whole bunch more. It even got more descriptive on the eyebrows later. Caterpillars, all kinds of crazy stuff. But it's absolutely right. That's the same sort of way when I do my version of Kohberger's the most unlucky guy in the world. It's exactly the same sort of logic that Chat GPT discovered during this conversation. So anyways, I hope you guys found that interesting, maybe even a little entertaining at the end there. But it was kind of nice to see that Chat GPT, using AI logic, had the same logic as the people that believe Kohberger is guilty, because that's what the evidence shows. All right, so thank you all very much for watching. And if you could hit that like button, share the video, and subscribe, that would be great. And as I always say, until next time, be safe out there.